So how are you spending your time? What are you doing?
I spend it at home with my family and try to looking into for a job and all that.
All right, how's the job search going?
Pretty well. I'm still waiting for an interview for the construction business, and I don't know if I gonna get a call this week or the next week, but maybe if I be able.
All right, just 1 second. Excuse me, if you all can't whisper, then you're all gonna have to confer outside. Daniel.
If I will be able, try to look for another job, see if they do not contract me on.
All right, and so are you doing school or looking into school or anything of that nature?
Not right now. I'm looking just for a job right now.
Any type of trade school or
Also,
trade school or anything of that nature? What are you planning on doing with your future?
for a GED.
All right. So you said GED?
Mhm.
All right, have you started working towards that?
So,
Say yes, ma'am, or no, ma'am, when she asks you a question.
no, not right now, ma'am.
All right, so it's probably best if he starts trying to get his GED if he doesn't have it.
Yes, ma'am, that's what you're working on, correct? Trying to get your GED?
Mhm.
Okay.
All right, so his GPS, what is the status of that? Is he on tracking or does he have scheduled
I
set
think
time?
he still has a full house GPS for the first 3 or 6 months.
Mhm.
And then after that, we're gonna reevaluate, I believe, if I remember correctly.
All right, it's been 3 months.
Yes, ma'am. But I think it was 3 months, but I'm not sure. I don't want to lie to the court.
No. Because I think it's time for him not to be on full GPS.
Your Honor, in December, the conditions were modified for partial GPS,
Mhm.
and there have not been any violation.
All right, and so then we said partial, I believe, I guess I probably said partial for work or to look for work.
Employment and mandated classes only.
All right. So are you okay with loosening that a little bit to giving him some extra time or no?
You're right.
Yes, I do see that, we have been in communication with him in regards to, certain job fairs and so forth. He's in compliance with all of his field visits, he's reporting on time.
So I think,
Judge, if we put him on track and he can go out and look for other jobs, he can stop at job sites and things.
well,
like that.
I think what I'll start with, because now it's just partial. I'll start with him being allowed to do things in certain hours. So if it's not work related, or if it's not for classes, I'll allow him to be out and about till 6 p.m.
Okay,
That means that you'll have to be at home at 6 p.m. Now, if you're at work and your work schedule takes you beyond 6 p.m., that's fine. So we'll start with that. And then the next time, if there are no issues, then we'll start with tracking only and then hopefully move towards removal.
so from what time to what time? I know from till 6 p.m., but what?
We'll
time?
do it Monday through what date? Do you want Monday through Friday or Monday through Sunday?
Judge, we don't have any, I would say Monday through Saturday.
All right. Monday through Saturday, we'll do 7 a.m. to 6 p.m.
6 a.m.
7 a.m. to 6
6
p.m.
a.m. to 6 p.m.
Okay, you want 6 a.m. to 6, okay.
Yes, Judge.
She's
That
fighting for
way,
you.
just because, just in case he gets a job to where he has to, you know.
All right, so your GPS now will be 6 a.m. to 6 p.m. That's whether you're looking for employment or whether you have a class or not. If you want to go to the park, then you can do that. So that's from 6 a.m. to 6 p.m. If there is something where you have employment and that employment takes you outside of that window or a class takes you outside of that window, let probation know.
Okay. Yeah, I will notify them if it takes longer than 6 p.m., sorry.
All right. So then what we'll do is we will see how that goes and we'll come back in 3 months. And in 3 months, it'll probably, if there are no issues, then it'll probably be tracking only. And then 3 more months, if there are no issues and nobody objects, it'll probably be removal.
Good. Just yesterday, it just happened that I got a call from an old client.
Mhm.
He owns a house framing business.
Mhm.
And he had some traffic tickets, so I went to pick up the money, pay the tickets. I'm gonna call him and see if he can use it.
Okay, awesome.
Okay.
Thank you. Johnny, you're so awesome.
Well,
I've known you forever. I've known you when I was a defense attorney and a prosecutor. You're just awesome.
well, thank you. So are you. That's
No.
why I love coming here.
Oh, thank you. So Norma, on this case, if you can give me a date to come back in 3 months,
What?
April 4th or April 11th.
May I look at my phone?
Sure. Or if you want a date other than that, just let us know.
Your Honor, while he's looking at his calendar, as far as the mental health treatment is concerned, are we okay just to monitor at this point? And if
Yes.
anything arises, let the court
Yes.
know?
We'll monitor. And if there is some issues that you're having, be sure to let your attorney know and let probation know, because we can't help you if we don't know.
Okay, ma'am.
And the last thing you want to happen is something that happen, and then you come back to this court and saying that you didn't tell anybody.
Mhm.
Because in this court, I believe that communication is key. When I place people on probation, I want them to be successful. So you have no excuse. And if the probation officer, who is your probation officer, is not addressing some issue you have, you can always call your attorney, or either you can always come to court.
Right, we'll do, ma'am.
All right, what,
April the 4th, Your Honor.
all right, Norma, we're gonna call this back on April 4th.
First one, after you finish.
So, este consumo como para ayuda psicológica, estoy en eso.
Mhm. You okay?
También the anger management, porque
Are you taking anger management?
no, es en hold. Es como,
Okay,
I see.
perdón.
all right, anything else that's needed?
He's wondering about something, let me find it for me, please.
No, perdón.
Something about anger management, but I don't remember anything about anger management.
Let me see.
Yes.
I don't have anything listed on the docket sheet that he's supposed to do anger management classes.
Anger management.
It was on hold until something happens or something like that.
Oh, so it's in abeyance? All right. Bashan, he has some concerns about his conditions. I don't have him down for anger management, but he thinks the paperwork he's reading says that maybe it's in abeyance or something. If you could review that.
Yeah, and I don't remember anything.
It's right here.
Yeah, have anger management held in abeyance.
All right, so yes,
That
you
was
don't have
on
to,
his original conditions
all right,
charge.
so you don't have to do that.
Not yet, you don't have to do that. That's why it says that, okay?
Mhm.
And I don't know if Johnny would like a copy of that.
This-
Yes.
Okay.
All right, is there anything else?
No, you on.
All right, thank you. Good luck
Yeah,
to
make a
you.
copy
Thank you
today.
for the good work.
Thank you, Your
I
Honor.
don't want
For
it.
her. Okay. Thank you.
10 minutes in, and the courtroom has found its rhythm. The judge balances empathy with order, GPS tracking, GED goals, and a limited 6 a.m., 6 p.m. window of freedom. Every privilege feels earned, every slip a risk. Behind calm words, tension simmers. This isn't chaos. It's a chessboard. If you were the judge, would you loosen control or keep it firm? Tell us below, and don't forget to like and subscribe for more courtroom moments like this.
Hi.
Hi. So where are we on the eval?
It's going on, I think, the 17th of this month.
Okay. Okay. And who is it with? Okay. All right, Norma, if you can give me a reset date for 45 days.
Yes, ma'am. I can do the 22nd. February 22nd.
All right, we'll come back on February 22nd. By then, hopefully I'll have an update on the evaluation. Make sure you make that evaluation, okay?
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you.
All right, thank you for dressing appropriately for court.
Of course.
Other side. All right, this is your third violation report. So it says that your device has not been calibrated.
Judge, I spoke to my client about that. I will tell you, he has some memory issues. He has some mental health issues that are going on. According to him, he's never been informed that he needs to calibrate it each month. I've explained that to him today.
Okay,
also
I know
told-
he's been informed that he needs to calibrate it.
I've told him he needs to start writing things down if he's not remembering what his pretrial officer or anybody else is telling him. As far as I know, he's been testing negative for all drugs, any alcohol. He's been on random UAs the whole time. He tells me he's not drinking. So it is his third violation. The two previous violations were a delay in getting the device installed. He does not have a vehicle, so we had to appear before you to get an in-home device authorized. So he hasn't been tested positive for alcohol, Judge. I have told him there are rules that he needs to abide by, and if he can't remember them, he needs to write them down. But we're set for a plea hearing next week. I anticipate getting it disposed off of your docket. I'm asking you to keep this.
Can't we get it disposed now? State is here, file is here.
I haven't reviewed the videos with him yet, Judge.
All right, if you all want to review, State, do you have the videos down here?
I can download it for him, Judge.
I have them in my possession, Judge. I'd like to review them in my office. That was the plan, was to meet with him this weekend, come back on Tuesday, let him decide if he wants to plea or go to trial on the case. I have two other settings in two different district courts today, and I have a misdemeanor case. So if you can give us until Tuesday, he's told me every single time, I'm not drinking, I'll test negative for anything. I think it's just a matter of logistics, not
All right.
violating his bond conditions.
So I understand what you're saying, but a lot of people say that they'll test negative and they're not drinking. But then they get tested and it turns out they're drinking. State, do you have anything to say with regards to this violation?
Well, Judge, this is the third one. I've conferred with defense and we thought we'd leave it in your hands. I know that it's set for next week. We have made an offer. I just, I know he wants to review it. We were thinking maybe the SCRAM might be appropriate, but I don't know if he's gonna even get that installed before it's set in next week, so. It's the third violation, Judge.
All right, I'm gonna have you all come back at 1:30 and you can watch videos with him over the break or either before. So I'm gonna make my ruling on this at 1:30. So everyone comes back at 1:30.
Thank you, Judge.
I got it. All right. So where are we on discovery?
This is the first setting. The state was gonna ask for time to reach out to the plaintiff.
Okay. All right, and Mr. Salinas, are you a citizen?
No,
All right, does he need an immigration attorney appointed?
Not at this point in time, I don't believe, Your Honor.
All right, so are you gonna handle his immigration issues?
Well, we're just handling the criminal side of it right now. Is he, all right,
No, he's gonna need an immigration attorney.
okay.
So are you all retained?
Yes, we are. If the
All right.
court deems it necessary, they can go ahead and start the process.
Well, no, are you all gonna pay for him to have an immigration attorney?
No, we're doing the criminal side of it. We're just doing the criminal.
No, I mean, well, the reason why I asked is because legally, immigration issues have to be addressed with him because he cannot enter a plea without someone telling him the consequences.
Oh, yeah, yes, I'm certified as an immigration law attorney as well, Your Honor.
Okay, all right.
However, I don't think he's gonna be pleading right now.
No. I don't want anything to hold up this case. I don't
Okay.
want us to have a jury trial and we can't go because the immigration issues have not been addressed. So you're going to address the immigration issues as it relates to this case with him?
Yes, ma'am.
All right, thank you. All right, Ms. Ferguson,
Yes, ma'am.
on Wilfredo Salinas, if I can have a 30-day reset, please.
Your Honor, I have a quick request as well.
Yes.
I didn't get information as to whether or not an amount is bail has been set
Mhm.
for Mr. Salinas. Is there any way we can get that amount set here, or do we have to set a separate hearing?
Oh, no, you just file a motion and we'll hear it if there is some bond issues. So
Okay.
you just file the motion and we'll hear it.
Okay, so I don't know if the amount set now will be considered to be an excessive amount.
Oh, if you all think that he can't pay that, then if you want to file a motion for a reduction of bond, the court will hear it.
Okay, all right.
Okay, thank you.
February 12th.
All right, we'll come back on February 12th. And yes, and Norma, Mr. Salinas is not a US citizen, but his counsel is telling me that he will handle the immigration issues as it relates to this case.
Is that at 9?
Yes.
All right, is there anything else?
Go, Your Honor.
All right, thank you.
Maybe, excuse Your Honor.
Yes. Okay. Do you know, is there an ICE hold on him?
The next 10 minutes reveal quiet friction, progress on one side, pressure on the other. A defendant nears a breakthrough, while GPS conditions tighten and mental health questions resurface. The judge's patience carries authority. One mistake could flip everything. Is this system built more to guide people or to test them? Drop your thoughts in the comments and make sure to like and subscribe for the next twist.
Your motions are lost in the system somewhere.
Joy.
So are you all okay with proceeding without his physical motions?
Yes, ma'am. I'm gonna give you the. Sure. Judge, can I approach this as the conditions of bond that have already been put in place?
We're going to go on the record. Court is calling CM 114217, 114220, and 114222, State of Texas versus Virginia. Cerna, can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Cerna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at 15,000. That occurred early in 2023. She, in late October of 2023, picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay, so today we're going to.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're going to be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at 75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're going to be asking for a bond of 10,000 each on the aggravated robberies, given the circumstances.
All right. And what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at 15,000, but we will go with whatever the court wishes to do.
All right. And state, are you prepared to proceed?
Yes, ma'am. We're ready.
Any witnesses? State or defense?
I mean,
None, Your Honor. I do have I'd like to give the court a packet. I can do it one or two ways, either, and I've shown this to Mr. Wilkins. Series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures
All
are.
right, any objections to defense exhibit number 1?
No objection, Your Honor.
All right, then the court will set exception to evidence defendants exhibit number 1.
And what the, if I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is Christopher Cooper, who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants and their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she
Right.
was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks. And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be 2 complainants with someone with a gun, but there is no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, but there's no face, but it appeared there's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm, but again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client. She has identified the 3 complainants, that being Jonathan, Joseph, and Christopher being the ones in the photos. And I'll also point out to the court that these photos taken from social media were my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to a La Quinta to see a just under 2-year-old stepsister that was born that Mr. Christopher Cooper has never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is a in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity if she's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness essentially of this allegation, we're asking that bonds be set of $10,000 on the aggravated robberies so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These 3 charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that the bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right, State.
Yes, Your Honor, we are asking that you double the bond on the aggravated assault deadly weapon from 15,000 to 30,000. And we're asking that on the aggravated robberies, that you keep the bonds at 75,000 each. We're also asking that you, she has these conditions of bond, the special conditions of bond, Judge, that I take to the court. We're asking that you keep the GPS with full house arrest in place, no contact with complainant witnesses in the aggravated robberies. Jonathan Gavel, Joseph Berrientos, and Christopher Cooper. A prohibition on possessing firearms. And Judge, I've previously tended to the court, the police report. I didn't mark those. I have stickers here if you'd like.
If you mark those as States Exhibits 1, 2, and 3. And defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then States Exhibits 1, 2, and 3 are admitted. And of course, defendants Exhibit number 1 is admitted. And you can tender those to the court reporter. I've reviewed those.
Okay, so just
And I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
just real briefly, the argument, in the police report, these are very serious allegations. We're asking that the bond be set at this high, or kept at this high number in order to protect the community. The code says that you can set reasonable conditions of bond. We think under the facts alleged in this police report, these are reasonable conditions, this amount, as well as for full house arrest GPS. And if you were inclined to grant a lower amount of bond, we would still ask for the other conditions, the full house arrest GPS, Judge. But I reviewed those pictures, and I think some of the questions that maybe the court had too. You know, this is a picture. I don't really know what this is depicting. This could be an airsoft gun. This could be a real gun. These guys could be engaging in blunting, or this could be tobacco. A couple of these guys are juveniles, so they have guns in these pictures that are undated. I think we don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not in any of the police reports. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest GPS, Your Honor.
And lastly, Judge, if I may, what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm, but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. So I don't know how he would see if there are guns or not in there.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
A few more things. No, I'm just kidding.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815 and CM number 114217. The court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. And cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna?
Yes, ma'am.
There's to be no contact with Ruben Cerna. All right, is there anything else?
Nothing, Your Honor. Thank you.
All right, Ms.
Oh.
Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, Judge.
All right, so that means it'll probably be 2 days. The earliest date you have. All right, we'll come back with jury trial on February 6th. If you're still in custody, you will be brought over in trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor, we thank the court.
All right, and do you know if your client will be going, if she were found guilty, do you know if she'd be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right, on Eric Lopez. All right, thank you. Yes,
Good morning.
good morning. Norma, on this case, when do you want to bring it back for jury trial? Daniel, this is yours. Yes,
So the court's aware, in speaking to one of the detectives involved in the case, she is currently pregnant. She did say, I think she was due in March, so if there's any time in between now and March that we could set this on.
all right, Norma, we'll need some time before March.
And-
Yes.
And then my understanding is that she's going on maternity leave for, I think, six to 8 weeks.
All right, when will that be?
I believe that's gonna be starting in March. It really is just kind of a rolling date because I think,
Yes.
because it just coincides with.
All right, so we're going to come back on February 6th for jury trial.
Now the stakes rise sharply. SCRAM orders issued, GPS unchanged. Defense and prosecution locked in debate. Deadlines close in as the judge measures risk against redemption. This is the razor's edge of justice. Follow every rule or lose it all. If you were defense counsel, would you fight the ruling or wait for another chance? Comment your move. And don't forget to like and subscribe for more real courtroom breakdowns.
All right, so, okay. All right, so can you give me a month reset? Is that enough time for everyone?
Yes.
Okay, all right.
I can do February 12th.
All right, we'll be back.
Defense counsel will be out. Remember, I don't come back until we try that case with Kathy Compton.
Yes.
I leave on the 8th, we'll be back the 18th. Then we start the trial, I think, on the 20th.
Which case are you, because are you on Eric Lopez with her or no?
No.
Angel.
Angel, okay.
The one that starts that Tuesday.
So let's put it on the same date as that.
Tuesday,
Yes.
That works.
February 20th.
All right, February 20th.
Yes, sir. Thank you.
All right, is there anything else?
No.
All right, thank you.
Thank you.
You're welcome.
I have.
John Anthony Ramirez. Who's the attorney for John Anthony Ramirez? Dinah, you ready? Are you all ready to proceed on the motion to revoke?
Yes, Your Honor.
Court is calling 2000. Please do not talk behind the court reporter. We're on the record. If y'all will remove it to this end. Court is calling 2016 CR 6340 State of Texas versus John Anthony Ramirez. Michael, can you all move it to that end?
Yes.
All right. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Could I have parties announced for the record for the state? Defense?
Renee Munoz on behalf of John Ramirez.
Are you Mr. Ramirez? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same John Anthony Ramirez who was placed on deferred adjudication in 2016 CR 6340 for the offense of aggravated assault with a deadly weapon on April 10th, 2017 for a period of 5 years and extended for a total of 3 years? State?
Violated condition number 5 in Bexar County, Texas, the defendant, John Anthony Ramirez, did then and there fail to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, we have already confirmed probation. It's for the defendant to report twice a month for 3 months virtually or in person. Monthly UAs for the defendant to continue treatment with the Center for Healthcare Services and to comply with his medications. And that would alter an amend, and we would ask that we did not.
All right, probation.
Your Honor, we did confirm that agreement. I'm sorry, the agreement is not. That is the agreement.
All right, so here's the court's issue. He's been here before me previously for not reporting. So how is this going to solve the issue? And I'm taking in consideration his mental health issues. So how is this solving the issue?
Yes, Your Honor. At first glance, I can see the court's concern. I spoke with my client and he did state that he was and is currently receiving services with the Center for Healthcare Services, Judge. He has been prescribing to them. I am receipts of a document from Jennifer Munoz, his case manager. I can tender it to the court.
Yes, please.
The court doesn't have an issue with that. He's been under their care for the last 18 months, Your Honor.
All right, you all need to whisper in the box. If you can't whisper in the box, then you can't talk in the box.
He's been reporting with them for the last 18 months and has been consistent with his appointments with them, Judge. He started off with pills, oral medications, but now he's on the injection. He takes once a month and he's now currently stabilized. I believe the issue was a little miscommunication with probation. I know that probation wanted him to try to get help at Palo Alto. My client states that he went to Palo Alto to get help and they said, we can't double up on your care. You're already seeing the Center for Healthcare Services. My client has stated that he can't afford the UAs and the probation officer essentially said, figure it out. And we are figuring out, Judge. His family's going to help contribute to that UA. So that's not going to be an issue. And I told clients that, no excuses in terms of not missing probation. If he needs to take the bus, he needs to take the earliest bus possible. So even if he misses a bus, he's on time. If he's there and they're saying they can't meet with him, to document that, to take a picture he was there, email me, email the court. Hey, I'm here. The probation officer is not able to meet with me at this time. He's wanting to reschedule, but he has been making his appointments regularly with Center, Judge, and he has been doing well with them. So it seems like he has a lot going on, but I'm telling him that he needs to make good on his requirements to the court and probation, that they need to meet with him, they need to see him. But his sister did furnish me that document from Center for Healthcare that he is receiving treatment, Judge. And I think he does seem stabilized to me. He does seem like he's wanting the treatment and he's already set up with the center. So we're respectfully asking the court for him to allow that. I did talk with him about the proposition before the court with meeting with probation. He has no issue going there down in person. He's going to take the bus. He's going to have family members take them. He's going to establish a better communication with the probation officer. I think has a year left after all the extensions, when it's all said and done, to expire in 2025 in April, Judge. So I'm encouraging him to give this last push. He's been on probation for quite a while. I think this case originated in 2016. So he has not picked up any new number ones. He has not demonstrated any violent behavior. He's demonstrated that he does need mental health services, and he is, he is taking measures to help himself in that regard, Judge. So we're asking the court respectfully.
All right, and probation, I'm assuming that you all will have access to his compliance with Center for Healthcare Services?
Your Honor, we'll ask for a release of information.
Oh, you have the release?
Yes, Judge, I filled it
Thank
out
you.
just in case we need the records from.
All right. All right, so I don't think it would be appropriate for him to have to report more often than he's currently reporting, because it seems to me the issue is his mental health. So if there's no objections, what I'll do is I'll deny the motion, alter the main conditions, and he's continue with mental health care with Center for Healthcare Services. He's you to make sure that you report monthly, you understand? And you are to provide a release so that the probation will be able to see how your treatment is going for Center for Healthcare Services. The court will note for the record that that release has been signed. Is that correct, counsel?
Yes, Your Honor. We have executed that. And
All right, is there anything else?
nothing further, Judge. We greatly appreciate the court's time and consideration.
Thank you, ma'am.
All right, Mr. Ramirez, we're off the record. If there is an issue, you can always come to court and let the court know what the
After nearly 90 minutes of rulings, arguments, and raw emotion, the courtroom finally exhales. Verdicts are handed down, lives redirected, and the echo of each sentence lingers long after the gavel falls. Justice today wasn't simple, it was human, equal parts logic, mercy, and consequence. Was this the justice everyone deserved, or just the best the system could give? Share your verdict below, and don't forget to like, subscribe, and stay tuned for more real courtroom stories like this.